Okay, let's start then. So good morning to everyone following us in Europe, and also good afternoon to those of us who might be joining from China. And welcome to our webinar titled IP Protection at Online Trade Fairs. So I am Helika Jürgensen. I am the project manager of China IP SME Help Desk, and I will be moderating today's webinar. Now, the COVID-19 pandemic has created a completely new form of trade fairs, where you can virtually exhibit your products as well as walk around in a virtual exhibition room and exploring the goods and services of others, finding potential partners or buyers. And the best thing of all, it's open for 24 hours. The initial success of the online trade fair suggests that this trend is most likely here to stay. However, just as with the regular trade fairs, there are IP risks involved with attending online trade fairs, as even more malicious entities have the possibility of visiting the fairs and take advantage of SMEs that have forgotten to protect their IP. Today, our speaker, Mr. Matias Zubimendi, will tell you what IP issues to pay attention to and how to safely attend these new types of trade fairs. But obviously, before we hear from Matias, let's talk about some practicalities. We are looking forward to an engaging webinar today with a Q&A session in the end, where you can pose questions to our expert. And we welcome you to type in your questions using the question box on your webinar panel. You can also see the control panel on the slide and use the question block box to ask us any questions. We welcome you to type in your questions using the question box on your webinar panel. And you can also type in the questions throughout the webinar. And Matias will then answer those during the Q&A session. Also, questions about practicalities, if you have any, will be answered throughout the webinar in writing, as well as the presentation slides will be shared with you after the webinar. Also, this webinar is recorded, and the recording will be made available on the China IP SME Help Desk website. Now, I would like to give floor to Jennifer Zhao, who will briefly introduce the China IPR SME Help Desk services before moving on with our presentation. So Jennifer, the floor is yours.
Yeah, thank you. Good morning, everyone, or good afternoon, everyone. Okay, this is Jennifer, and I'm very glad to have this chance to show you a brief picture about our organization. China IPR Help Desk is a European Union-funded project. It's designed to help European SMEs with intellectual property right issues in mainland China, Hong Kong, Macau, and Taiwan. This project offers a variety of services that enable EU SMEs to make informed decisions about IP rights, and all these services. Our core services including inquiry helpline, events, and materials on website. The inquiry helpline is for EU SMEs to ask us any IP-related question and receive a reply with 3 working days. So just send us your question to this mailbox. China IPR SME Help Desk also organize training seminars and live webinars all over China and Europe. And it covers various topics range from basic IP training to tailor-made seminar on specific issues, for example, this time. And normally we organize these events together with Chamber of Commerce, business associations, cluster organizations, and embassies. So please feel free to contact us about organizing training seminars or webinars. And all scheduled events info are available on our website. Besides this event info on our website, you will also find various resources on IP issue, in podcast, guides, infographic, and case studies. It also contains a comprehensive library of IP guidelines, which is covering all major IP topics. Consists of trademark, copyright, patent, and trade secret. Here is an example, and as we also offer industry-specific guides, such as IP in the Industry 4.0 or IP in the ICT industry, as well as the detail like how to record your trademark with the customs authorities, or how to remove the counterfeit products from e-commerce website, etc. So this is all about us. You're always welcome to send you anytime. Thank you.
Thank you, Jennifer, for this detailed introduction to China IPR SME Help Desk. And before we move to our main presenter, I would now like to invite the Executive Director of Flanders China Chamber of Commerce, EUChina Business Association, Ms. Gwen Song, to share some welcoming words as well as introduce both organizations. Gwen, the floor is yours.
Thank you. Ladies and gentlemen, good morning. On behalf of the EU-China Business Association, the Flanders China Chamber of Commerce, I would also like to warmly welcome you to our fourth joint webinar with the China IPR SME Help Desk. As a chamber, we attach a lot of importance on IP, and we think that companies doing business with China should also have an IP strategy included in their China business plan. Today, we are experiencing difficult times, especially in Europe because of the corona, but China is recovering from COVID-19 and things are almost back to normal in China. Economists now believe that the 6.8% decline in Q1 Chinese growth could be positive in the second quarter, signaling a successful recovery. During a recent survey of European companies in China, European companies stated that they remain committed to the Chinese market and that it remains their top 3 destination for investment. And furthermore, a majority of European companies said that Chinese firms were equally or even more innovative than European firms. They rather see an opportunity in an increasingly innovative China than a threat. And China has already become a leader in innovation in several areas, such as the internet industry and artificial intelligence. China also became the world leader in international patent filings in 2019, with about 60,000 applications overtaking the US. The EU and China are negotiating the EU-China Investment Agreement, and this offers an opportunity to increase trade and investment. It will also offer new and better market access for investors in Europe and in China. The aim was to sign this agreement in 2020, and we hope it is still the case, taking into account the COVID-19. Speaking about investment, European investment in China for the full year of 2019, the value of completed European FDI transactions in China reached $12 billion, which is up more than 70% compared to $8 billion in 2018. The top industries were automotive, agriculture, and food and consumer products and services. For 2020, automotive and financial services are picking up as China lifts equity cap requirements in these sectors. Speaking about Chinese FDI in Europe, the completed Chinese FDI in Europe was $13 billion, down again from $21 billion in 2018, but higher than Europe's investments in China. The top industries of Chinese investment were consumer products and services and automotive. Let me mention a few words about the EU-China Business Association's role and activities. The EU-China Business Association is the association of bilateral China business associations in Europe aiming at promoting the economic and trade relations between the EU and China. Today, we have 19 member associations and represent more than 20,000 European and Chinese companies. The aim is to be complementary to the national level so that the member companies can work on a larger scale and can deepen their cooperation with Chinese business partners. The Flanders China Chamber of Commerce is a member of the EUChina Business Association and supports companies doing business with China. Our chamber was founded by the largest investors from Belgium and China, such as Ageas, Bekaert, Barco, Picanol, Umicore, and so on. Our aim is to help Belgian companies expand in China and to assist Chinese companies to invest and do business in Belgium. We provide a weekly China business newsletter, organize webinars on how to do business in China, and give expert advice. Normally, we also receive many Chinese delegations that we can introduce to you, but we do hope in the second half of the year to start this again. But looking at the situation now, I think Chinese delegations, we will also still have to wait to receive them. But in the meanwhile, we work online and try to solve this. We are at your disposal for any further information and also welcome you for a talk on how we can further assist you with your business with China. Thank you.
Thank you very much, Gwen, for this introduction and for your welcoming words. And I must also thank you for emphasizing the importance of IP protection, and especially in those difficult times. But now we're moving closer to our main topic, and our speaker today will be Mr. Matias Zubimendi, who is the IP business advisor at China IPR SME Help Desk. If you use our helpline, then Matias will be the person who will answer all of your IP-related questions usually. But before I will give the floor to Matias for this presentation, let's do a warm-up survey. We would really want to know who has already participated in online trade fairs or who is planning to participate in online trade fairs. And I will be starting a poll to see who has participated at online trade fairs. So I will give everyone about less than 60 seconds to answer to the poll. And when I see that most of the people have voted, then I will simply close the poll and share the results with you. So let's give a few more seconds for everyone to vote. I can see that 80% of you have already voted. So let's see if anyone else wants to vote. Let's see. And I can see that the majority has voted. So I'll be closing the poll and I'll share the results with you. And now everyone can also see the results. We can see that 14% of you have already participated at trade fairs. This is already a really good result, taking that the online trade fairs have been around for only about less than even 3 months. So that's really, really good. And I can also see that another 36% of you are definitely planning to attend trade fairs. So you're all at a right place, and definitely this presentation will be interesting for everyone who has already participated, or to people who haven't yet participated, but they might be planning to participate at an online trade fair. So thank you for taking part of the poll, and now we will move on with our presentation. And I'll be giving floor to our IP business advisor, Matias, to start the presentation on how to attend safely the online trade fairs and what issues to pay attention to intellectual property rights wise.
Thank you, Helika. Do I have control of the screen? No.
You will have in a moment.
Sure.
Yeah, if you open yep, perfect.
Okay, welcome everyone. Today we're going to talk about online trade fairs and also trade fairs in general, how to protect your IP when you are attending an event like this one. On the screen you can see the content of today's presentation. First, I will introduce what intellectual property rights are and highlighted what are the main aspects of them that we should take into consideration when we are considering attending a trade fair. I will also discuss a little bit about the differences between online and regular trade fairs, what are the main risks when attending to a trade fair, and what to do before, during, and after the event. Finally, some takeaway messages. But let's start with the introduction to intellectual property rights. There are 5 main intellectual property rights, or 6, depends how we want to see it. First, we have innovation patents and utility models. Those protect the functionality of a product, but they also protect processes. What they protect are inventions. This can be any kind of product or process that has 3 or fulfills 3 requirements: novelty, non-obviousness, and industrial application. Novelty means that this innovation should be new, should not be known by anyone else in the entire world. It shouldn't be published, it shouldn't be exposed. So now we start seeing why, when we attend to a trade fair, why we have to take into consideration the requirements of a patent, because if we expose our products, the products will lose novelty and will not be able to be patented. The second requirement is the non-obviousness. That this means that the technology should be innovative enough in order to, in the sense of, that an expert on the field should be able to look the state of art and not come up with the solution that the patent is offering. Finally, the third requirement is industrial application, which means that the product or the process should be able to be applied in the industrial production. What's the difference between innovation patents and utility models? Well, the main difference is that utility models are considered like small patents because they share the same requirements. However, how severe or how tough is the office when checking if those requirements are fulfilled are more relaxed in the utility models. Another difference is the length of the protection. While in innovation patent is 20 years, in utility model is 10 years. But most importantly is that innovation patents, the average time for registering a patent is 3 to 5 years, while for utility models it's only 1 year. So it's very common for companies that they do a parallel registration of innovation patents and utility models in order to obtain first the utility models and then get the patent and discard the utility model. The second intellectual property right is the design patents. In this case, this type of patents protect the aesthetic aspect of the products. This means the shape, the pattern, the combination of colors. It also has to be novel. This novelty has to be global. This means that, again, the design cannot be disclosed or exposed anywhere. There is a small difference here between China and the EU. Normally in the EU, design patents do have, unregistered design patents do have certain level of protection. There is a grace period of 3 years where they will be protected even if they were not registered. However, in China, all design that is not registered will not have any kind of protection. So if you want to protect your design patent in China, register it before disclosing it, otherwise the novelty will be lost. Trademarks. By trademarks is any sign that is capable to identify a product or a service in a certain market. This is what the trademarks are protecting, is the distinctiveness of a product, the capacity to catch attention in a certain market and to canalize the investment that the company has made into advertise, because the consumers will recognize the product, will recognize the brand, and get the product based on that, on the face that this product has certain level of quality and or it was produced by a specific company. There are different types of trademarks. It could be the name of the product, it could be the name of the company, it could be logo, it could be picture, it could be 2D, 3D. In general, it's every sign, every aspect of a product that has a chance to make the product distinctable in a market, it can be registered as a trademark. In the case of China and the EU, there is also not the difference, but the characteristic, I would say, that in China, since the consumers are not used to read our alphabet, it is very common that trademarks are translated into Chinese characters. This translation can be done in a literal way, meaning that if your trademark has a meaning, there is an object or a name, it's translated into the Chinese version, the literal translation. The second way that this can be done is a phonetical way. This means that through the sound of the Chinese characters, there is a replica of the pronunciation of the original name of the trademark, but it's advisable to do a comprehensive translation. This means that we a company copy the name or the phonetical pronunciation of the original trademark, but at the same time paying attention to the full meaning of each character selected, because for native speakers, each character has a meaning, so it's translating, is communicating certain values, and the company will be connected with the values of its name. And from a merchandising point of view, it is important to communicate good values and do a proper translation. Copyright protects the expression of ideas. What we look for here is the originality. This means that our production was made by our work and it was not copied. So this is important for SMEs because by copyright we are not only talking about art like paints or books, but we are also looking at software, databases, the manual of a product, pictures that are going to be used, our advertises. So it has certain level of importance even in trade fairs. Finally, trade secrets. Trade secret is any information that has value, that is being kept secret and is being protected for that. So in the definition, we can find these three requirements. First one, that it has a value because of being secret. This means that it provides a competitive advantage for the company, or simply, for example, reduce the cost of production. Second, that is secret. This means that it's not known by the vast majority of the competitors. It can be known by more than one, but the important thing is that it's not commonly known. And the third requirement is that the trade secret has to be kept secret through protective measures. This is that there has to be a certain level of protection organized by the company. This kind of protection can be physically for example, with the seal of confidential in your documents, but also has to be contractual with the non-disclosure agreements, or even informatic, for example, with having your own server and limiting the access to the server to only those people that need to work with these trade secrets. And for the principles, there are two important principles that we should take into consideration when we are talking about intellectual property rights and online trade fairs. The first one is the registration. In China, IPRs that are not registered will have almost no protection at all. The only intellectual property right that doesn't need to be registered is trade secrets because of the nature of this intellectual property right. But we have to take into consideration that when registering, there is also another rule that will play. It's called the first to file rule. This means that the company or the person that made the first registration of a trademark or of copyright or a patent will have a priority over all future registrations. So in the case of trademark, for example, even if the registration was done in bad faith, that person that did the bad faith will have a priority, and it will be very difficult, not impossible, but very difficult to take down the registration. The second principle is territoriality. That works as a limit of your intellectual property rights. This means that the registration done in a country will only have effect, and the protection will be only within the territory of this country. So our trademark register in Europe will not have any effect in China, except if we register it in China. So when we are planning to attend to a trade fair, we should know where this event is happening, in which country. So we need to plan in advance to have protection in this specific country. But in the case of online trade fair, this becomes a little bit more complex, because we have to discuss where online trade fairs take place. But let's discuss a little bit about the differences between online and trade fairs. I saw in the poll that almost half of you didn't attend to a trade fair, so I will introduce a little bit how do they look like, what are the main characteristics. I personally attend to 4 trade fairs, online trade fairs already. My impression is that they will look like an e-commerce website. Normally you have a list of exhibitors, but also you can look for specific products, specific type, normally through specific types of products, and you will see them exposed. When you enter, you will be able to see the information about the company, to make a purchase, to ask further information about the product, to even ask for a meeting. Also, during the online trade fairs, there are regular events, normally are webinars or videos. There are 2 types. There is one type of event that are normally organized by the organizer of the trade fair. Normally, it's like a welcoming ceremony, some specific promotions of the trade fair, of the place, of the main companies, and finally like a goodbye ceremony. But also online trade fairs, they allow exhibitors to give their own presentations, to give their own events, and they work in a private way. I mean, public and private. Private in the sense that you have to enter there, you have to go and look for it, but it's public because everyone can attend. So in those events, they promote their products, and normally you can organize a meeting. There are online trade fairs, as equally as regular trade fairs, they are matchmaking events. It is possible to make some contacts, but as in my experience, it's a little bit of a limited experience. There is no, it's not yet very well developed. It is an ongoing project. You can also do purchases in the online trade fair. That this could work as a method to check the quality of the products. Normally in a regular trade fair, you will have the product there. You will be able to see the quality, how it looks, how it, the shape, everything about the product. In online trade fairs, you cannot. You will only have a video or just simply pictures, maybe a draw with some technical description, but no more than that. So, but you still have the chance in most of them to buy just a simple sample. So this way you will be able to check the quality. The limitations is that there is no real contact, and you don't have a very comprehensive knowledge about the companies you are dealing with. The pros is that online trade fairs are cheaper and everything is exposed, so it's easy to have access to the entire offer of expositors. And in the case of an IPR infringement, it's going to be easy to obtain evidence to later prove that there was an infringement. But where do online trade fairs take place? Because there is a debate about what's the jurisdiction of websites, where if I can access to the online trade fair in my own country, is this trade fair happening in China or is this happening in my own country? Where are the limits? What law are going to be applicable to online trade fairs? And most importantly, will my trademark register in the EU will be capable of or will be enforceable in the online trade fair? This debate that it's going on, I would say that in a practical way, within the duration of a trade fair, you will have no chances to discuss these kind of complex topics. So in order to make it easier and to make it more practical, we have to say that the online trade fair is happening in China, and the laws that are going to be applicable are Chinese law. But also you have to take into consideration that both regular trade fairs and online trade fairs, they do have their own method and rules and procedure for complaining for IPR infringement. So these rules will also be applicable because it's going to be faster and effective. So when considering what laws we have to take into consideration, or what rules we have to take into consideration, are going to be Chinese laws and the rules of the online trade fair. So in which country should I protect my IP? As I said, even if the trade fair is happening online, you will have to protect your IP in the country of the organizer. In our case, will be China, but it's in the organizer's country. Well, what do I mean when I say to protect my IP? What I'm trying to explain here is that the best way, considering the registration principle, is to register your IP in that country. But what are the main risks in a trade fair? When my company is attending to a trade fair, what do I have to pay attention to? What are the potential dangers to my IPRs? Let's go one by one with our IPRs. In the case of patents, and here I'm talking about innovation patents, utility models, and design patents, the main danger is to lose the novelty requirement, as I mentioned before. Because novelty has to be global, and novelty is going to be checked during the registration process. Any disclosure may invalidate future protection. This means that your company will have to pay very specific attention when planning to attend to a trade fair and when deciding what kind of products or what kind of designs will be exposed, because the designs on these products and the technologies on this product should be registered already before this disclosure. In the case of China, there is an exception for patents. If the online trade fair or regular trade fair, it is an international exhibition sponsored or recognized by the Chinese government, there is a grace period of 6 months for making the registration. But again, this should be, well, you should be talking about an international exhibition that it should be sponsored or recognized by the Chinese government. So better not take the risk and not to expose any product that hasn't been registered yet. What do I mean with disclosure? What do I'm trying to explain when I say keep your novelty safe? I'm talking about not making the product or the design available to the public. So of course, if you upload a picture of your product design to the online trade fair and everyone can have access to it, then here we are talking about a disclosure and the loss of novelty. If you show your product that contains a specific technology, but that specific technology is it's located inside the product. So let's take an example. For example, I have a new phone. My company produces a new phone, and there is I have an innovation patent on the battery, and the battery lasts twice as long as a regular one. If you just upload a picture of your phone, how it looks, but the battery content inside and the technology in that battery is not exposed, then there won't be any problem, because no one will be able to know about this new technology just by looking at the phone picture. So when we are talking about what to expose, is not to expose that part of the patent that will be protected with the patent. But what happens in private meetings? If I'm an exhibitor and someone asks me for a private meeting because they want to order a huge amount of my products, can I negotiate with them? Can I show certain level of can I show more to that particular person? I would say first no, but there is the chance that in the case of a very important client or very important potential client, that you may be interested in disclosing certain a little bit more of information. In this case, you can cover yourself with a non-disclosure agreement. In this case, you are treating the patent and the novelty as a trade secret because it hasn't been registered yet. And remember, trade secrets work for trade secrets are not registered. So those patents that are not being registered yet will be at the same time, will be in the future a patent, but in the meantime, they are trade secrets. So in this case, you can have an NDA agreement with them. Of course, making an NDA agreement, it's very complex. You should, at the end of the day, also trust the party, your counterparty, and it's not so simple of just giving NDAs to everyone approaching to you in a trade fair. But this chance, it still exists. In the case of copyrights, what are the main risks? The main risk is for use to be copied. In online trade fairs, this is less likely to happen because, again, you are just, by copyright, you're protecting pictures, advertises. You can protect software, but what kind of software can you expose in an online trade fair? Maybe there is a chance. I haven't seen it yet, but maybe there is a chance. So in this case, you will have to protect it by copyright. In the case of pictures, yeah, someone can copy your pictures, but it's not the most common scenario. In the case of trademarks, again, the risk or the danger is to be copied, but most importantly is that someone see the potential of your trademark and just make a bad faith registration. It also could happen that someone will register your trademark with the only purpose of after that selling to you and getting some money. Remember that there is this principle, first to file. Even if the registration was done in bad faith, this person will have a priority and you will have to take down the registration. And it's not an easy thing to do in China. So by easy thing to do, I mean you will have to go to court, and normally these processes take more than a year. So, and yeah, and you will have to pay your own lawyer. So it's going to take longer and it's going to be more expensive. It's possible to make it, but it can be frustrating for those companies. Also, you have to take into consideration what I mentioned before, the translation of trademarks. Maybe your company, in order to attend to it could be a regular trade fair or online trade fairs in China, and to get closer to Chinese consumer, company can order for a translator to translate the manuals, the advertise, and it may happen that this person makes a translation of your trademark. So Chinese speakers can read it in Chinese characters more easily. In this case, I will give you two advices. First one, check what is this translation, what characters are being used, that they communicate good values. And second, if the trade fair will be the kickstart of the promotion of your trademark in China, this could mean that in the future your products will be known with a Chinese name rather with the original name. So if you want to make a registration, register both trademarks. This means register the original name in Western alphabet, but also register the Chinese version of that trademark. There is a very famous case in China that is Michael Jordan name. Someone registered the Chinese characters for Michael Jordan. It was a bad faith registration, and it took Michael Jordan more than 10 years to get it back. In the meantime, they created a whole industry around this name. But this example shows how the Chinese name is going to be the name the name which by whom or by what the person will be known, or your company, your products will be known. Most likely your Chinese name will be more important than your original name, even though you may have more attachment or more feelings for your original name of your trademark. In the case of trade secrets, again, we are talking about secrets. So as soon as they become public, they are lost. So my advice for the risk here is for trade secrets is for them to be exposed, to be shown. As already mentioned, that future patents are a trade secret. So if you disclose them, you will lose the potentiality of a patent. In the case of other trade secrets, avoid them to expose them in in a regular meeting, even with an NDA. The NDA will cover you, but again, I consider it very risky. So the general rule would be, do not take any sensible information to a trade fair. In the case of online trade fair, it would be don't upload any sensible information to the platform. The problem here is that what happens if by mistake you upload a trade secret? Well, if the trade fair is already going on, you may lose your trade secret. So it is advisable that your legal department, or at least someone that has certain knowledge about intellectual property rights, and particularly what the trade secrets of your company are, to double check what information, what description it is being uploaded to the platform. For example, as I mentioned before, the example of the battery on a phone. Let's say that you want to upload the picture of your phone where you cannot see the battery. That's perfectly fine. The trade secret and the potential patent will be safe. But if you also upload the technical draw of the product, and you also start in the description, start talking about how this battery works and why it's better than other batteries, well, in this case, you may be losing your trade secret because you may be exposing the confidential information, the innovative part of your new technology, and in this case, you will be disclosing your trade secrets. So as you can see, it depends a lot on each case, and it is advisable before uploading information, or when deciding what information will be uploaded in order to promote your products, to double check that no trade secret is going to be lost. It is also important to teach your negotiators, which means the person that will be the sellers, or they will be having the private meetings with future clients, to know what information disclose and which one do not disclose. But I imagine that one of your questions would be like, what can I do if the online trade fair is happening relatively soon and my registration takes longer? Because as I mentioned, a patent can be 3 to 5 years. A trademark could be around 8 months or up to a year, but the trade fair is happening relatively soon. What can I do? Well, in this case, you have two options. The first one is to treat everything as trade secrets, but in this case, you won't be able to disclose information, and most likely you won't be able to promote your products. And the second option is to anyways start a registration. Even this registration that is being in the process will not be enforceable during the trade fair, unless you will be saving the intellectual property right for the future, because as soon as you started the registration, you will have a priority over future registrations. So even though you won't be able to enforce it, your IPRs will be safe for the long run. And once these IPRs are granted, you will be able to go for a potential infringer. Maybe during the trade fair, you just get some information and you start studying and analyzing your new competitor, your new rival. And then when you have all the tools, all your intellectual property rights, then you start enforcing them. Of course, my tip would be think trade fairs in advance when you are making a product, and when you are thinking about promotion, take into consideration the possibility of trade fairs. China is a country that is very famous for its for the trade fairs. There are thousands of people, and they're very international, and they're very well known with huge reputation. So it is advisable to to include China as part of the protection countries, so you can protect them in this kind of event. So what to do before the trade fair? First, prepare your IP strategy. Register as soon as possible, as I just mentioned. What should I register for attending to a trade fair? In the case of innovation, patents, and utility models, the products that are going to be involved, the products that are going to be exposed, what you have to register is the object of the patent, is that the claims of the patents will contain one specific technology. Okay, if this technology is going to be exposed, then you have to register it with the patent. In the case of design patents, very easily, what you have to register is the appearance of your products, the design. In the case of trademarks, it's advisable to register your company name, the logos that are going to be published or exposed, the name of your product, and the Chinese, as I mentioned before, the Chinese name of those trademarks. And what to register as copyright? Well, if you're going to show software, register the software, register the pictures, the manuals, the advertise, any draw that is going to be exposed. It is common for companies to show a picture of the product, but also a technical draw with more characteristic or specifications. This can be protected with copyright. In the case of copyright protection, there is also an alternative if you don't have a registration, or you cannot do a registration in the copyright office. In China, there are courts called internet courts. They are settled in Beijing, Hangzhou, and Guangzhou, and they do have jurisdiction over online copyright infringement. I will talk about this a little bit more later. But what is most important is that the Supreme People's Court of China published some instruction for them and making them capable of accepting electronic evidence. So, since copyright, the registration is not technically mandatory because the protection begins with just creating the expression of your idea. The registration is for the sole purpose of proving it. Then it is possible to do an electronic, and by electronic I mean a registration with blockchain. This is, you upload in a blockchain your expression of an idea, your picture, your draw, your software, your manual, and you will have a very solid method to prove that you are the author and this expression was done in a certain very specific moment. So, considering that online trade fairs happening online and internet courts protect online copyright infringement, then you will be able to use this blockchain information, this blockchain registration in this kind of lawsuit. How to proceed is my company has trade secrets. As I mentioned before, do not show them. Avoid exposing the trade secrets and hide it, as I explained in the example of the battery and in the phone. Just expose as much as you can without exposing your trade secret. Do not show try to promote your product without showing how your technology works, what are the main characteristics that make it work in a certain way. So no one that is an expert on the field will be capable of replicate your technology with the information provided in the online trade fair. Also, before the trade fair, prepare your team, decide who will participate in the fair and assign them roles, decide who are going to be the negotiators or your sellers, instruct them not to disclose your trade secret by mistake, and teach them how to use NDAs and to protect the potential sensible information with important clients. Also, establish some people to control. This means to make surveillance of other exhibitors, to check live events, to see if your competitors are stealing your technologies or your trademarks. Teach part of your team about how to collect evidence in online trade fairs, and another part of the team about how to enforce your IPRs. This means that make them get familiar with the Chinese law, but most importantly with the specific rules of the online trade fair, so they will know how to go to the complaint center and yeah, start a procedure to enforce the IP rights. Normally, both regular and online trade fairs, there is a complaint center where you can go to talk to these people and start a small procedure that will be decided within the duration of the trade fairs in order to take down the products that are being infringed. These two parts, collect evidence and enforce, most likely will be the same people. It would be your legal team. Yeah, they just need to know that the event is happening and to be ready, being capable of acting fast. As I said, the complaint centers, they are very common in all regular and online trade fairs, and they are kind of efficient. How to collect evidence or how to proceed if I detect an IP infringement? The first thing you should do is to collect evidence before enforcing. Get all the evidence, get all the proofs that you will need for acting later. The most efficient way of obtaining evidence is with a notary. In the case of China, you will need a Chinese notary. What this person will do is to prove that a certain product or is being offered, that has certain trademark, that has these characteristics, and it is offered under these terms, everything. This way, this person will be able to give faith in the future that this offer and this product was offered in this way. So you will be able to make a comparison with your own products, trademarks, and IPRs and detect if there is an infringement or not. Blockchain is another method of obtaining evidence. With blockchains, you can download the information available on the website, put it in a blockchain. This information will not be modified at all, and if it is modified, the blockchain system itself will make obvious that the information was modified. So it is a method that it is acceptable, as I said, in the internet courts, but most likely will be acceptable in the future in regular courts. So it is advisable to consider blockchain as a method of obtaining evidence. Of course, when I'm talking about notary and I'm talking about blockchain, I'm not talking about exclusive methods of obtaining evidence. What I would do is to use all the alternatives to get as much as information and as much evidence as is possible, and yeah, just get as much as you can. Another method is to purchase some samples. If you order online a sample, you will receive it. You will be capable of proving that you obtained this product from them. This should be done with the assistance of a notary. So the notary should record that you order online, that you made these specific orders. It is advisable to send this sample to the notary's address, so this person will receive it, make a description of the sample, and yeah, you will have a record of obtaining this product from them. So if this product is being counterfeited, you can prove it. Another method of evidence, or at least more information about the sellers, is that during the online trade fairs, you will have available certain level of information of these companies. Normally, it is the name, the name of the, I don't, like a representative or someone that is in charge, where it is located, no more than that, maybe just a brief description. But if you go to the National Enterprise Credit Information Publicity System, that is a public database available for everyone. It is in Chinese language, but if you need assistance, you can always contact the helpless and we will provide help. In this public database, you will find all the information about every single company registered in China. So just by getting information by the name you got in the online trade fair, if you copy paste the name in this National Enterprise Credit Information Publicity System website, you will obtain full information of the company. This means who are the shareholders, where it's the official address, who is the legal representative, what's the capital, what are their intellectual property rights. Everything is available there. And finally, it is advisable to contact your local attorney, and by this I mean your Chinese attorney, because if you're going to take further steps, it's better to consult with them. Okay, this evidence that I collected, is it enough? What else can I do? Should I get something else? It's going to be useful in future actions, and this way you will be more effective. And during the trade fair, as I mentioned before, you can go to the complaint centers, or you can directly go to local courts. In general, I would say that the complaint centers have certain advantages and disadvantages. Advantages, and they're faster, they're more effective, and they will remove immediately the infringing offer. But the disadvantage are that you will not get compensation for that infringement. The seller will keep operating out of the trade fairs, and this way you will not be solving the real problem at the end of the day. You will still have a bad faith seller working in China, producing in China, and yeah, you're not solving your case. So you will have to decide if you go to local court or complaint center. Again, these are not exclusive alternatives. You can go to one first and then go to the second one. So I would advise you to go first to the complaint center to remove the product from the trade fair, collect evidence before that, and then go to the local court. If your action in the complaint center is unsuccessful, you can still go to the local court and ask them to enforce your IP rights on your on the specific trade fair, even if it is happening online. And as I mentioned before, in the case of copyright online infringement, you have the chances to go to internet courts, which are a very interesting alternative because they are really fast, and the whole procedure takes place online. Even the hearings, it's like a webinar. It happens online, and it's normally it's about 28 minutes. I think that's the average time of a hearing, and the time is around 20 to 25 days, the whole procedure. So they are really fast and effective, and you will be able to obtain compensation. So this should be taken into consideration, but it's only work for copyright infringement, not for trademarks. So take this into account. But there is a very interesting technique that it's happening in China, that many bad faith sellers that are registering as copyright trademarks, so they obtain a valid certificate from the Copyright Office, and they show to e-sellers that they have certain level of IP rights over these trademarks, and they are allowed to sell online. But you can do the opposite. You make a copyright registration of your trademark and then go to the internet card saying that there is a copyright infringement during this online trade fair, and this way you will be able to go to the internet court and have the whole procedure in a short period of time and online. And what to do after the trade fair if you discover an infringement? First, register your IP rights with the Customs Office. This is especially useful for trademarks. This way you will be able to stop the bad faith seller to exporting the products abroad. This will damage your counterparty. Second, you should keep researching the infringing participant to get more information. Again, go to the National Enterprise Credit Information Publicity System, and you will get all the available information there. Keep researching the e-retailers on the online websites in order to detect if this bad faith seller was before selling online, for example, in Taobao or Tmall. Check if your products are being offered there. Get more information about that. You can try with a cease and desist letter to stop the infringer to keep insisting in his or her actions. Finally, if you have all the evidence, you try with a cease and desist letter and you didn't succeed, okay, then you can go to court. But before that, look for a good Chinese attorney in order to be successful. Some takeaway messages. The first one is register your IP in advance. This is when you are planning to launch a new product, and when you're thinking about the advertise, consider China as part of the promotion and the registration. Most or many of the most important trade fairs in the world happen in China, so it is advisable for global companies to include China. Do not disclose your trade secrets. This is very, very important because this is the most relevant risk and what companies should pay attention the most to. Get familiar with the IP complaint rules and procedure. This is very important for your legal team because your legal team has to be ready to act, has to be ready to collect evidence before starting any action, to know how to collect and get as much as it is possible. And during the trade fair, keep an eye on the infringers. Finally, contact the China IPR SME help desk. Here on the screen, you can see the email. We are a helpline that is free, fast, and confidential, and we normally reply within 3 working days. So if you have any inquiry, now, we can talk about them now. But if later something hits your mind, you can send an email, and I will be more than happy to reply to. So let's proceed with the Q&A section. Let's see if Helica or Jennifer are with me.
Yeah, thank you. Thank you, Matias, for this excellent presentation. We learned a lot. I mean, I have never attended an online trade fair before, but I really learned a lot from your presentation about the online trade fairs. But now, I'm sorry that we have run a little bit over time. But regardless, I think the topic is very interesting, and we will proceed with the Q&A session where we will take all the questions that have been asked. So still, even though we're a bit over time, please still use the question box, type in all of the questions you might have, and we still take the questions. So we have already the first question, and someone would like to know how long does it take in an average to deposit the trademark, and as well as how much does applying for a trademark cost. Matias, over to you.
Yes, the average time is 8 months to up to a year if there is no opposition and all the procedure is clean, in the sense of there is no problem, that the trademark was well registered in the proper classes and subclasses, and again, no opposition. And the cost is 300 RMB, the fee. In euros, it's something around, let me calculate quickly. 37, almost 40 euros, just the fee. This includes 10, includes one class with 10 subclasses, and then if you want an extra subclass, it will be 30 RMB per subclass.
Yeah, thank you. Thank you, Matias, for this. Let's see if we have more questions, and we can see that there's another question about the internet courts. And do the internet courts conduct a substantial examination on your copyrighted work? If you record copyright for your logo, but it is a simple logo, does the enforcement work? Or the court can say that the work was not protected through copyright? Matias, over to you.
Yeah, it is a full procedure. There is a comprehensive analysis. The fact that everything is happening online, it doesn't mean that the procedure is less strict. So when you are applying starting a lawsuit in the internet court, you should be capable of explaining every single aspect. You should be able to give the certificate of your copyright or the blockchain registration. You should be able to explain why your copyright is being infringed and what are the damages, what is the compensation. In the case of if a logo, again, as I said, it's not, internet courts are not for trademark infringement, so you should be able to explain why you have a copyright infringement. So it is a method, it is an alternative, but it has to be explained very efficiently, very well. So it is an alternative. It doesn't mean that it's an easy alternative.
Thank you, Matias, for this explanation. And if there are any other concerns about the internet courts, of course, please follow up with us via using our helpline. And I see one more question. What risks could be associated with uploading your product information to a virtual exhibition room, and how to avoid those risks? Over to you, Matias.
Well, I don't know what you mean with product information. If you only provide simple information about your products, as the size, the weight, some features, that there won't be any risk. The most important part to take into consideration are trade secrets. This means that you don't disclose any characteristic of your technology that can be a future patent. For example, let's talk about the example of the as I mentioned, the phone and the battery. If you explain that your battery lasts twice as any other battery, that's okay. You're not disclosing how your battery works. But if you start disclosing that your battery works with this material, or that I don't know, because I don't know much about batteries, but the energy is being distributed this and this other way, so this way you can charge it faster and you can save double energy. Well, in this case, an expert on the field will see these characteristics and maybe will be capable of discovering how this battery works, and then the technology will lose novelty and lose non-obviousness. So when you are disclosing characteristics, you can disclose those characteristics that helps your product to be promoted and compare with your competitors. But do not show those characteristics that make competitors capable of knowing how your product works. I hope I was clear about this topic. If it needs further information, just let me know.
Thank you, Matias, for this excellent explanation. I can see that currently there are no further questions, and as we're also over time, so I think it's time to end the webinar for today. And obviously, if you're going home and well, you're at home following us, but you might have further questions later on, then obviously you can send us an email, ask any questions, and we will answer within 3 working days. Now, I would also like to thank Matias for this excellent presentation. I would like to thank Gwen for organizing this webinar, for inviting us to speak at the webinar. And I would also like to thank each and every one of you for attending today's webinar. So this is it from my side. This ends the webinar. Thank you, everyone, and bye-bye.
Thank you, everyone. Have a nice day.